I want to talk to you guys about after you've been denied and lost your appeal with Hartford, the only remaining remedy is a lawsuit. And the lawsuits in this world of ERISA, which is what these Hartford claims are governed by, are very, very unique. A lot of people think nowadays they watch this show called Suits, or they watch Law and Order, and they see these trials and they think, I'm going to get my lawyer and we're going to go in and we're going to nail them and we're going to take depositions and we're going to get them on the stand and then the jury is going to decide. But Alex, you know that's not the truth. So talk a little bit about what is happening in a Hartford long-term disability lawsuit.
So what makes these type of cases so unique is that ERISA, Employee Retirement Income Security Act, governs these policies. And what the ERISA does, like you said, it takes away your right to a jury trial. So you have a federal judge ultimately rendering a decision on this claim. Typically, most of these disability insurance policies have discretionary policies or discretionary language in them. Everyone's going to say, watching this video, what is that? Well, basically, those paragraphs give the insurance company the discretion to award or deny benefits and review the information and render a decision on your case. What that does is that typically under most lawsuits, when a judge is deciding a case, they get to do it de novo and basically say, weigh the evidence and say, hey, I find this person to be disabled or I find this person is not disabled. So if I find the person is disabled, I disagree with the insurance company's decision and I'm overturning their decision, putting the person back on claim. With ERISA, there's a discretionary clause. Normally, not only do you have to prove to the judge that you are disabled under the terms of the policy, that you're disabled from your own occupation or any gainful occupation, whatever the definition of disability is, but if there's a discretionary clause, there's a next step. And the next step is to prove that the decision by Hartford in denying your case was arbitrary and capricious. Very difficult standard. So ERISA, for lack of a better term, screws people over because it takes away the right to a jury trial. You know, a jury trial would be great because you'd have 5 or 10 or 12 jurors of your peers. People, they see themselves in your shoe. The little man going against a billion-dollar insurance company, and they're saying, look how they're screwing this guy over. Let's pay this person their benefits. You don't have that. You have a federal judge, who's been appointed to a seat for life, answers to nobody. I guess the appellate court can overrule them, but if they get it overruled, nothing happens to them. So you have a little person going against a billion-dollar company, federal judge rendering a decision. The law is really on the insurance companies, in favor of the insurance companies. Very difficult to win. That's why we go back to the appeals. The appeals are so important because the lawsuits are just so difficult to win. But they're winnable. We win them.
No, I mean, look, we win these lawsuits, but let's talk about in terms of, Stephen, what is a win? What does a win mean in a lawsuit? When I kind of equate a win when talking about a Hartford disability lawsuit as to the available remedies, because if you walk away with money in your pocket, you've won. When you place a bet and you get nothing, you've lost. In this situation, there's multiple ways to get to a win. Talk about what those could be.
Yeah, a win is recovery, right? So federal courts, almost all of them, rare cases they don't mandate, but they mandate a mediation. So at some point during the process, there's going to be a date where Hartford and their attorney and you and the client are going to come together to try to reach a resolution and a settlement. And going back to what I said earlier about the strength of the appeal, is about getting to the money. The stronger your case is, the more risk that Hartford has going into it, the more they're going to value the policy. So recovery in most of these cases are going to, historically settle at some point prior to a judge making a final decision on it. Because like you said, you could go to the judge can say, no, I'm sorry, side with the insurance company, which happens a lot in this area of the law, and you walk away with nothing. And you may think that you have a very strong case, and we can think you have a strong case medically, but there's that extra nuance of that discretionary review always causes a little bit of friction. So as one mediator put it, a successful mediation is when both parties walk away mutually dissatisfied, right? There's give and take on both sides of it.
The values of settlements vary. They're all over the map.
Very much so.
People look, what's it going to settle for? Well, it depends on the facts of your case.
It depends on the valuation, the facts of the case. I mean, I guess you can say in a historical context, most insurance companies are probably going to try to get up between 10 and 40% of the value. So 10 to 40 cents on the dollar is where they will historically fall. Sometimes lower, sometimes higher. It really depends. If you do your own appeal and you don't add enough information to give you a fighting chance, well, the valuations on your policy are going to be very low. So that's why everything is tied to the appeal. The litigation, is really in all ways just it's tied to the appeal that was done. So when you get into mediations discussions, the strength of what was before, what's in your file, is going to dictate the value that they're going to look to. And with Hartford, when they reach a resolution, it's a clean break. You're surrendering policy, surrendering future coverage.
Right, that's one of the best things
Everyone
about
goes
it.
their own way, right? You never will get, some people think, like you said, with court, I'm going to get my day in court and I'm going to get vindication and justice. Even if you win, you just get what you're owed, right? There's no extra damages. There's no punishment for Hartford. They're never in a situation where there's really a financial disincentive not to fight you.
Why is there no punishment or punitive damages? A lot of people call us and ask us that.
So in this area of the law, going back to when it was first, written, to be able to provide insurance to employers at a low enough rate that they could actually, insure their employees, there's tons of concessions. And with that is that the only legal remedy you have is the benefits they owe you, right? Not even futures, right? So if you win your case in front of the judge is going to say, pay the person what you owe them up to date, unless there's like situations they denied you an own occupation. Judge can only award through that period. But pay you what you owe you, put the person back on claim, and then Hartford starts reviewing again. Judge can't say, you can't cut this person off again, you can't pay them future benefits. I'm just going to say, hey, almost like the judge is doing an appeal review of the appeal review, and saying you pay them what you owe them, put them back on claim. There's no rights, guarantees to your attorney's fees and stuff. So it really creates a situation between what Alex said, where they get the benefit of the doubt legally speaking. Like I think Caesar said it, it's the benefit of the doubt standard. The judge is always going to give the benefit of the doubt to the insurance company reviewing everything. And even if they're wrong, well, their worst day may be just paying you what they owe you.
Right. I know we've made it sound a little gloomy, but the reality is that if there is that discretionary clause, which is a little legally technical, because it is, you can still win these cases.
No, you can still win these cases, but I think it's also important that you understand it's an uphill battle. It's not like what you see on TV, right? It's a very nuanced, specialized area of the law.
The one thing about it, and we do talk about these discretionary clauses, I have never seen a case where a judge said, I find you're disabled, but I think the insurance company acted reasonable. Even though a lot of people and we ourselves talk about how bad this standard is, and I think the insurance companies not in the back of their minds, this is front and center what I tell them in every mediation. If this judge believes that you are disabled, then he or she is going to find a way to say they acted unreasonable, because they're going to say, how did you ignore that particular doctor? How did you not put weight into that MRI? How did you not consider that test? So what that comes down to is, as you said earlier, a super strong appeal. But if you didn't do a super strong appeal, you then have to have a lawyer who knows every single nuance in your claim file, which can be thousands and thousands of pages, and has a knowledge of thousands of ERISA lawsuit decisions that have been out there in the past, because that is one benefit. These cases are litigated all the time, and there's cases on both sides. For every one thing where we can see a fact pattern, we could find a judge who said, I find the person's disabled, they acted unreasonably. Then we find another court, different judge, different human being who says, same exact fact pattern, person is not disabled. So that works our way too, because we go to the insurance company if we're skilled enough to find those cases and say, look, here's this fact pattern. This court said, that the person is disabled. Then they're going to come with their case if they find it and say they're not disabled. So these are all the things that we make arguments to create value. At the end of the day, a number is going to come to our client, and the client's going to make that decision.
And I think one thing that's important to add for anyone who may be watching is, because if you're getting to the point of having to file a lawsuit, say you did your appeal on your own, you're probably beat up and tired, right? Not necessarily want to deal. And you do think that, oh my gosh, if we file a lawsuit, it's going to be, very impactful in my life, and they're going to follow me around and do all this. I think it's also important to know that the litigation aspect of this, right? We don't get juries, you don't testify, things of that nature. But I guess the positive side to that for the client is they're not going to be harassing you, your family, your doctors. Right. They're not going to try to bury you in requests for information and make it miserable for you. The judge isn't going to hear from you. So it really is not going to take anything out of your life. So I say that in the sense that, yes, they've beaten you down, but your worst case scenario in court is exactly where you are. no money coming in from them. You only have upside. So if you're even thinking about, do I want to continue this? I always say push the fight, because at the very least, they're going to make monetary offers to you.
100%. You can't walk away from your case just because you're tired.
Mm-hmm.
They hire us to take on your stress. That's what a lawyer is sometimes. I tell my clients, you hired me to take on your stress. You forget about this, I'll take it over from here. That's what I do a lot of times with my appeals or with my lawsuits. That's what I tell them.
Well,
It's the truth.
I tell everyone out there, call us with your denial. We'll provide you a free consultation. We'll let you know immediately if we can help you no matter where you live in the country. And we look forward to speaking with you.